Hello guys, my name is Amaan. I'm a legal intern at LEXIS and Company, and I'm pursuing 3 years of faculty of law at university. Uh, and the topic of my today's video is Section 482 of the CRPC, its power and how can court exercises, and also one landmark case related to it. So, in the purview of the inherent powers of the High Court, it is found that Section 482 CRPC is somewhat of a peculiar nature in criminal jurisprudence. It seemingly comes out to be the most powerful tool conferred by the procedural codes for the High Court in the Indian Constitution. It means that this prescribed section can be used by the High Courts of a particular state, and such inherent powers are never subjected to be taken away from the High Court away from High Court by the Superior Court. So the Code of Criminal Procedure 1973 in Section 482 CRPC reads that saving of inherent power of the High Court, nothing in this court shall be deemed to limit or affect the inherent powers of the High Court to make such order as may be given necessary to give effect to any order under this code, or to prevent abuse of the process of any court, or otherwise to secure the ends of justice. So however, such powers can be used by the courts in the interest to do complete and satisfactory justice between the party before it, and also doing the abuse of the process of the court. This is applied with such an inherent power under Section 482 of the CRPC of the new code, to do justice and to undo the wrong, so as to the course of the meeting, the end of the justice, and the stop abusing the process of the court proceeding. It is pertinent to mention that uh, it is pertinent to mention herein that such intention of inherent powers of the High Court must be used sparingly. So this section was added by the CRPC Amendment Act of 1923, and the main intent of the amendment that it was found that the High Court were unable to deliver complete justice for which they were established, when it was found out that the case given case shows ex facie or something prima facie illegality, which were many times apparent. So however, it is Karwas that this section has invested three circumstances where such inherent judicial power may be exercised. They are to prevent abuse of the court of justice, to secure the ends of the justice, and to give effect to an order under CRPC also. So these power under it are very wide and are at the total discretion of the court. To understand in coherence to the object of 482 CRPC, it may be conducted from the points such as under section 482 of the CRPC. The inherent power of the High Court is the most powerful weapon, and it definitely operates in a peculiar way in criminal jurisprudence. Such a procedure mainly used to clean the province of criminal procedure out from all kind of vitiating and malicious influences. Then such a conferred state of power, however, not available at the subordinate courts, and this is obvious for decreasing the pandemonium that may likely increase in the criminal justice system. So such inherent powers are conferred to the high courts of the respective states. So it is also backed by a case law of De Devaraja versus Uwais Sabir Hussain of a 2020 case, which was in which Supreme Court laid down a very good uh, uh, judgment, in which the case was the brief facts of the case. This is the case in which the complainant had filed a complaint against the police officers alleging police excess, where he was kept in custody and was put into investigation in connection with the crime he was accused of. Then Metropolitan Magistrate had taken a cognizance of the private complaint, and such an order was challenged before the High Court for quashing of the criminal proceeding by filing a petition under Section 482 CRPC. The stated petition by the alleged police officer was filed on the ground that the complainant did not take any sanction from the government to prosecute the accused police officers. So, however, the High Court refused to quash the criminal proceeding and remitted the complainant back to instead with the liberty to the accused of filing an application for the discharge. So the imposed order of the High Court was set for an appeal in the apex court, and hence this instant case arose. So the bench hearing and proceeding of the matter consist of Justice R. Bhanumati and Indra Banerjee, Justice Indra Banerjee, and observed that apparently the complainant pertains to the act under the color of duty. They choose to opine that as a prima facie the matter falls under the color of duty, and hence sanction appears to be legal framework for empowering the court to take cognizance. The High Court in the instant case, Supreme Court held that High Court in the instant case had erred in not exercising its inherent power under Section 482 CRPC to quash the complaint instead of remitting the appellant to file a discharge application under Section 245 of CRPC. So in front of then Supreme Court laid down that with this while this court has in Virusaka case held that High Court has erred in not setting aside an order of the trial court taking cognizance of the complainant in the exercise of power under Section 482. this code head, it is not always necessary that the need for sanction under section 197 is to be considered, as the complainant is lodged and on the allegation contained therein. So the complainant may not disclose that the act constituting the offence was done purportedly to be done in discharge on official duty and under the color of duty. However, the facts subsequently coming to the light in course of the trial or upon police or judicial inquiry may establish the necessity for sanction. Thus, whether sanction is necessary or not may have to be determined at any stage of proceeding. So, it is also well settled that an application under section 482 of the CRPC is maintainable to quash proceeding that are ex facie bad or for want of sanction frivolous, or they are thwarting or abusing the power of the code. And if on the face of the complainant the act alleged appears to have reasonably relationship with official duty, where the crime proceeding is apparently prompted by malafide and instituted with an ulterior motive, then power under 482 of the criminal procedure code will have to be exercised to quash the proceedings of the to prevent abuse of the process of the court and give justice to the aggrieved party. So this was a very wide ambit of section 482 that was given in the CRPC, and the Supreme Court also in this case said that the court should not shy away from using this power and should use it pertinently to help the process of the justice. So thank you. I want to conclude this video, and please remember this video does not solicit or promote any of this video and violate any guidelines of bar council of India, does not solicit or promote any of the advertisement, and the sole purpose is educational. And please subscribe to the channel if you haven't already to see more of this content in the future, and I'll be coming up with the next video very soon. Thank you.